Madison County judge in the state of Illinois saying that the law limiting where people can file lawsuits against the state to just Cook County or Sangamon County isn't going to fly. In a case brought by Thomas Magg challenging the state's firearm industry liability law. And this was also including a challenge to the state law that ultimately says you can only sue in Cook or Sangamon County. Welcome in, Bishop on Air. I'm Greg Bishop. Thanks for hanging out with me each and every weekday morning. And let's go ahead and get into this. Be sure to like, subscribe, and hit that notification bell. But you've got the story that even the Center Square had months ago. All right, and that is this legislation that ultimately passed both chambers to limit where people can challenge laws in the state of Illinois. So let's pull this up from the archives at thecentersquare.com. This is from June 7th of 2023. Pritzker signs bill limiting constitutional challenges to 2 counties, which opponents said is tyrannical. So let's go ahead and read through some of this and even hear some of the debate that happened on the floor of each the House and the Senate. So back in last summer, effective immediately, Illinoisans wanting to challenge the constitutionality of state laws or executive actions in state court can only file litigation in 2 of the state's 102 counties. That contentious measure passed both chambers along party lines and says that citizens can only file litigation in state courts in either Sangamon or Cook counties. Governor J.B. Pritzker signed that bill. Now, the House sponsor of the bill, Jay Hoffman, said that the measure seeks to limit venue shopping by litigants. Republican State Representative Dan Calkins fired back. Here's just some of that debate. Let's see if we can pull this up here, unmute that, and here we are.
Indicate that Sangamon and Cook counties are the only venues proper for Illinois constitutional claims. Over the past 3 years, the Attorney General's office has been forced to respond to, I would call them in many cases, frivolous lawsuits that have strained the office's limited resources.
This is the same Attorney General's office that has requested from this body additional authority to investigate and bring actions against crisis pregnancy centers this session, to bring actions against and investigate gun manufacturers this session. It doesn't seem that the Attorney General's office is lacking in resources when they're constantly coming to this body requesting more authority to do things. So I think that argument strains credulity.
So it goes on from there to where you've got the argument made, this is more efficient, right? So that the Attorney General can only focus on having to address these types of things in Sangamon County, which is in Springfield, or in Cook County, which is in Chicago. Now, some misconceptions here. Sangamon County is a Republican county. It's not to say there aren't liberal judges in circuit court in Sangamon County, but it's a conservative county. It's a Republican voting county. Cook County, of course, a different story. But, a lot of people point to Chicago being Democrat, and some said that Springfield's Democrat. Well, Sangamon County, that's not the case. There's more Republicans in Sangamon County than there are Democrats, at least when it comes to election outcomes in most instances. So moving on, you've got that law that ultimately passed, regardless of the back and forth. And then you had Attorney Thomas Magg. In June of last year, he filed a lawsuit, and part of that lawsuit was this indication of saying the venue limiting bill was not good. So a new law where citizens can bring some legal action against the state only in Sangamon and Cook counties already faces a legal challenge. The attorney who filed the case in Madison County dared the Attorney General to transfer the case, calling the new law blatantly unconstitutional. So here we are now, fast forward, and you've got this case that was decided earlier this month. And again, shout out to gunsavelife.com. They got this order that was issued on March 1st. And we'll go ahead and pull this up and read through it a bit and give you an idea of what we're looking at here. But in Madison County, you had Piasaw Armory challenging Kwame Raoul in the state of Illinois on the firearm liability law. But also in that was a complaint about limiting where courts, which courts could hear these types of cases. So just reading through this, Thomas Magg being the attorney in this, and for the following reasons, the court denies the motion to transfer that the defendants and the state made and grants Piasaw Armory's motion for summary judgment. By the way, real quick here, Is it Piasaw or Piasaw? If you're in the comments, be sure to spell that out phonetically for me. Listen, I've lived in Illinois a long time. Even when I lived across the river as a small kid in the suburbs of St. Louis, we would come over and check out that crazy bird that's painted on the cliff. It's just incredible. But is it Piasaw or is it Piasaw? The Piasaw bird, either way, I'd love to see you in the comments in the live chat to correct me on the phonetics of that. But back to this case here. So we read through, and ultimately what we see is that you have the various complaints that are made. August 17th, 2023, they filed their complaint. Piasaw Armory seeks declaratory and injunctive relief concerning the Firearm Industry Responsibility Act, which amended the Consumer Fraud Act. All right, so Tnieber says it's Piasaw. So we'll see if anybody else corrects him or if that's the way it's said. Then you also have, back to the case, Piasaw Armory contends these amendments violate the Supremacy Clause, First Amendment, Second Amendment, Fifth Amendment, 14th Amendment of the United States Constitution, and the three readings rule of the Illinois Constitution, which is an interesting thing that seems to happen a lot. But anytime people try to challenge the three readings rule, it doesn't really seem to go anywhere. But anyways, so they contend all of these various things, and therefore, they go through the background and some case law. Piasaw Armory opposes the Attorney General's motion to transfer this, arguing that it violates Amendments 1, 2, 5, and 14, and the three readings rules of the Constitution, and so on. Because the Attorney General has moved the courts to transfer this case from Piasaw Armory's preferred format, the court finds Piasaw Armory has standing to challenge the constitutionality of the statute. So they go through even more of the arguments, look at some case law from even the Illinois Supreme Court dealing with making sure going to court is convenient. And you have various other elements of these arguments that the state made, that the plaintiffs countered, and that the courts took into consideration, and even to the point where the plaintiffs proving that they have this burden of possibly going to Sangamon County from Madison County, or possibly even Cook County from Madison County. Plaintiffs submit affidavit seeking that Madison County is convenient for him and Sangamon County is not. Plaintiffs' counsel and plaintiffs itself located in Madison County. While the location of plaintiffs' counsel is not entitled to such consideration, just as in the forum non-convenience analysis, it is entitled to some. For its part, state cites to not a single witness that it would actually call that hails from Sangamon County and does not provide a single affidavit on witness convenience. Transfer to Sangamon County also totally prevents the possibility of jury view, such as plaintiff's store, should there be a dispute about plaintiff's business. The state contends that Piasaw Armory has failed to establish that its corporate representatives are incapable of traveling to Sangamon County. While it's indeed possible for witnesses to physically travel long distances, the issue at hand pertains to reasonableness and convenience, not mere physical capability. Piasaw has asserted that its corporate representatives have chosen to handle prosecution of this case in Madison County. The state's made no effort to counter that claim or provide alternative witness. Consequently, the state's presentation or lack thereof falls short of the precedent set by the Illinois Supreme Court. In Williams, the student loan borrowers presented evidence showing the inconvenience to Cook County. Piasaw has presented similar evidence, and goes on to talk even about remote proceedings and how, we have remote proceedings in the state. But the court said that does not bolster the state's argument. The state could also participate in Madison County using the same remote means. So it's interesting. The state in their case says, hey, we can move to Sangamon County because we got remote proceedings that we can do. Well, the court countering that, saying that, well, if that's the case, the state can also take part in remote hearings with it being held in Madison County. Certainly for persons with appropriate computer equipment and subscriptions, which the court takes judicial notice of, includes the Attorney General's office, as they do often appear in court remotely by Zoom and the like, making some hearings more convenient. But that does not follow that all persons have such equipment or subscriptions. There's nothing in the record to suggest that plaintiff or its employees have such equipment, which may well be relatively common for lawyers, but not all persons are lawyers. Additionally, the service is not without flaws, as the court's experience suggests that complex factual matters requiring documentation are best dealt with in person. Online remote appearances, much like telephone depositions and appearances by telephone, which have been done for literally decades, are most useful for simple matters and less useful for more complicated and disputes. Other types of matters. The court takes judicial notice that telephones were in widespread use. Thus, contrary to the argument of the state, the remote appearance option was available to student loan borrowers if one includes the use of a telephone in the term. Now, the Illinois Supreme Court, it gives more case law and talks about Sangamon being an inconvenient format, just as Sangamon County was inconvenient in an oil and gas case brought by the state in People ex rel. Madigan. Sangamon County is simply inconvenient to plaintiff's witnesses, and defendants list no witnesses that Sangamon County would be convenient for. While hardly entitled to any weight, even the location of the plaintiff's counsel in Madison County, while documents may be relatively easy to move, there's no showing that any relevant documents are anywhere other than Madison County. Furthermore, by abolishing forum nonconvenience under the statutes, the procedural safeguard of forum nonconvenience is eliminated. It talks about more case law and an example of why technically proper venue for the state can be unreasonable for a private litigant, and how forum nonconvenience can ameliorate that. Essentially just blow that up. Unfortunately, this protection has been abolished by the state. So interesting to see the court lay this out in this document, and ultimately saying that the state's motion to transfer this case to Sangamon County is denied, and seeming to also highlight how this particular measure limiting where people can file lawsuits is non-constitutional, unconstitutional. A finding of unconstitutionality is necessary to the decision of judgment rendered, and such decision of judgment cannot rest upon an alternative ground, and there's no alternative non-constitutional argument that can be applied. Accordingly, the motion to transfer to Sangamon County is denied. PSL Armory's cross motion for summary judgment in count 5 is granted. The court finds Illinois Public Act 103-0005 unconstitutional as applied. Pursuant to the Supreme Court Rule 304, this court finds no reason to delay enforcement or appeal this order. The defendant is expected to appeal this order, but they got to do it within a certain amount of time, 30 days from March 1st. So there you have it. A judge has determined that a law limiting the venue for where people can file lawsuits against the state of Illinois is unconstitutional, and that law has been challenged in federal court as well. So we'll see where this goes. I'd have to do some follow-ups and find out how this impacts the law and other various lawsuits that are challenging state law on constitutional grounds. So always a fascinating day, no question about it. Here with Bishop on Air. Thank you so much for hanging out with me each and every weekday morning, and we will, of course, keep you updated on all this and more here with Bishop on Air.